important word here is it will be introduced in phased manner. It will not be introduced at once altogether for all the things. So just like as we understand that IBC itself has not started fully, it has started in phases. So right now, as we understand that it is for the corporates, and then for personal guarantors it started, and now it's still pending for the individuals and the partnership firms. Similarly, here also the expert committee is saying that mediation process should be given as an option. But again, this will be introduced in the IBC in a phased manner. And again, this will be a voluntary mediation. It will not be made compulsory. Okay. So voluntary mediation as a dispute resolution mechanism under the code, while maintaining the sanctity of the timelines for various existing insolvency resolution processes. So while maintaining the timeline of IBC itself, if people want, they can even go for the mediation. So again, one more question, which at least it comes to my mind, it is like, if you go for mediation, what will happen to the limitation act which is applicable? So whether it will fulfill the conditions of limitation act, or that period will be excluded from the limitation time limits. So again, the question here arises is, if any person voluntarily goes for mediation, then the time which is taken in mediation, whether that will count for the limitation period, or it will be excluded from that limitation period. Should I take the question right now? If any one of you is ready to answer that, what is your view on that? What will happen to the
It
time
should be
period?
excluded, ma'am, in my view.
Yes, sir. It is excluded. It is clearly mentioned in the this Mediation Act also. So if we read both the things together, it says that that time period will be excluded. And of course, the regulation will come if this will take place. Then regulation will be provided by the IBBI how to take it further. So in that way, that this part will be clearly mentioned that if anyone is going for voluntary mediation, that time period will not be counted ultimately. Uh, Third point, the core essence of the framework is its independence and flexibility to provide room for quick incorporation and implementational learning. So the main object behind giving this thing of I mean this mediation a kick is that it will create a kind of flexibility and a quick incorporation or a quick resolution of your prolonged disputes, or your the things which we want to end up quickly, that will take place with the help of this mediation. This is what this expert committee pointed out, that since IBC is taking long, though we don't want it to happen, but let us, why not to use this as a tool? This mediation act should be used as a tool so that we can, quickly summarize the things. We can quickly end up the long proceedings which are continuing. So what are the benefits of mediation? If I talk generally also, then it says that it is a neutral, safe, resolution oriented thing. It is less expensive than litigation. Obviously, it is completely confidential, because this confidentiality clause itself in the Mediation Act also. There is a separate section with respect to this confidentiality. Then there will be control of the outcome of our future. I mean, whosoever is involved in that mediation, it is up to them what they want to do. So the ultimate outcome will be in their control. So if they want to settle down the things, obviously they will finalize it that way. And if they do not want to settle the things, then ultimately this mediation will not be very much of effect, and the negative report will be issued by the mediator. And then they can further take this to the IBC. So that is the whole scenario. That is the flow of events which will take place. So in short, what we can say is, what are the benefits of mediation? Is firstly, it is faster, it is cost effective, and it is confidential as an alternate, and it can be used as an alternative to litigation. Secondly, it encourages stakeholders, cooperation, and consensus. So basically, wherever it seems that yeah, the stakeholders can come together, they can sit together. Just it's a matter that one person should make them sit together and just discuss the things. If at all it can happen. In that case, it should be the mediation should be a very good choice. Then third and most important thing is it reduces stress on NCLT and NCLAT and the judiciary. So as we know a lot of litigation cases, can you please mute yourself? Yeah, others, please mute yourself. Thank you. So basically, this whole concept is introduced to reduce the burden or the stress which NCLT and NCLAT are having because of long pending cases in front of them. So that is why this mediation seems to be a good approach. Sir, can you please mute? Anjali ma'am, can you please mute from your side? Kindly mute the participants. Yeah, if you want to say, yeah, if you want to say anything, just you can unmute and then you can probably speak up. Thank you. So let us move further. So at this point of time, I mean, it is not very much clear whether mediation will be a good approach or not. But as per the expert committee, they are saying that it should be a good approach, or it is just a way to delay the process even more, because you are first wasting your time in mediation, then ultimately you think you will come out with no resolution. Maybe it is still at the same place, and then you are filing an application in this IBC. So what is the point of wasting your time in mediation? Why don't you directly take this IBC approach? Why to go for this mediation? So some people have this view that we should directly go for filing section 7 or section 9 applications directly. We should not enter into mediation. Some people are of the approach that we must first at least try this mediation so that our litigation part will not be very cumbersome, or it will end up very soon. If we go for mediation, it will quickly turn out to be fruitful. So there are both the school of thoughts which are available, and there is no conclusion to it how it will go, but the time will tell us ultimately whether the mediation is fruitful or not. And it may obviously vary case to case also. So if any of your clients, they want to go for mediation, you should firstly analyze the whole situation, whether it is fruitful for them to go into mediation. It all depends whether the other party is willing to talk, whether the other party is willing to cooperate or not. So if the other party is not at all willing to settle the things, it's I don't think the mediation is a good choice. But again, if you want to just try, it is an option given. So what is the global perspective with respect to this mediation? So is it mediation only being introduced in India? No, it is, or it was already there in other countries. It was already existing globally. So let us see where all it was there. So in United States, if we talk about, US bankruptcy mediation program is there, and over 60% of Chapter 11 cases. Chapter 11 is basically insolvency there. So mostly 60% of the cases are resolved through mediation in United States. So they already are into the practice of this mediation. So there is a case study of this Lehman Brothers bankruptcy. Here, mediation was used to settle complex creditor claims very efficiently. So ultimately, we understand here that in United States, there is already a system of mediation. What about United Kingdom? In United Kingdom, pre-pack administration mediation helps companies restructure without court intervention. So in not in all the scenarios, but in pre-pack administration, like we have that pre-pack insolvency here, maybe there is something over there in United Kingdom also. So in pre-pack administration, they have this kind of thing, which is called as mediation. And there the court is not involved and the things get resolved through mediation. And there is a case study also, Carolyn Plank insolvency. Mediation facilitated settlements with subcontractors. So Normally we understand that if there are many contractors or there are many subcontractors and the list of creditors is long, then it takes a lot of time to settle the issues. So it's better to have a mediation with them, and then out of court settlement can be done. So it was done in the case of this particular thing, United Kingdom's case. In Singapore also, there is a system of mediation. So Singapore Mediation Center resolves insolvency cases within 3 months. So they have a deadline that if anything is coming to this mediation center, they will resolve this insolvency case within 3 months. So whether it might happen that either the parties are in favor of mediation and they are settling their things or disputes, and if even if they are not settling, whatever the outcome is, within 3 months, yes or no will be done by the parties, and next level will be taken up. So there is a proper deadline in Singapore at least. So mandatory mediation for commercial disputes, and again in Singapore there is a mandatory mediation for commercial disputes, and this is a thing which we will also see in the Mediation Act 2023. In India also, they have made it mandatory in few cases. And what are those cases? We will see that. So they have also used this term there, commercial. So we will understand what is the meant by commercial dispute. And in case of at least commercial dispute, there is a threshold limit also which they have given. For that particular those disputes, mediation is made mandatory. So, being a professional, we should understand that while drafting the agreements or contracts, normally it is our habit that we put a arbitration clause in that. Nowadays, with the advent of this Mediation Act, what will happen is you will also have to put this mediation clause in your agreements or contracts. So, this has to be taken care that there has to be a separate clause for mediation as well. So this is what is required. And the act also says about it that you should have a mediation clause in all your agreements or contracts. And if it is not there, how you can take up mediation. If you really want to take up mediation, either it should be mentioned in your contract or agreements, or otherwise also you can opt for it. So there are different sections for that, how you can opt for mediation. Let us move further. In European Union, EU Directive 2019-1023 promotes mediation in restructuring and insolvency. So they are also promoting this mediation concept. Here there is a case study. Here they are saying that Italy's insolvency mediation framework, they expedited the creditor settlement just because of with the introduction of this mediation, they could expedite the creditors settlement. In Australia also, this thing is existing. So insolvency practitioners, they are trained as mediators to facilitate out of court settlements. So here you can say that, see that, I mean, the insolvency practitioners are allowed to become mediators. They can act as a mediators, and in fact, they are trained to become a mediator so that out of court settlement can take place. And there is a case study also here, Arium Limited restructuring, where mediation reduced litigation costs and time. So India can learn from all these global practices, and from these different countries' perspective, we can understand that the future is institutional mediation and online resolution. So it is better to try to at least go for mediation rather than going directly to the NCLT and other judiciary things to for clearing our disputes. So again, there are different terms which we must understand at this point of time, which are there for dispute resolution. So they are called alternative dispute resolution, like facilitation, arbitration, mediation, negotiation, litigation. So what is it all about? It how one term is different from the other. So we must try to understand to have the basic understanding why and why these different terms are there, and what is the scope of these terms. So if we talk about, we will just discuss these four terms: conciliation, arbitration, mediation, and litigation, and what is the difference between all of them. So the first basis of difference we'll try to figure out from the process, how the whole process goes. So in case of conciliation, there is a conciliator who facilitates communication and suggests solutions. So it is a kind of active approach. Either both the parties themselves sit together and they reconcile amongst themselves, or they have a third person who is known as a conciliator, and then uh, there is an active approach, and whatever is suggestions are coming out, they can take up. It is optional to them to whether they want a conciliation or not, or whether they want to go with the conciliation conclusion or not. In case of arbitration, again, there is a third party. An arbitrator listens to both the sides and makes a binding decision. So, in arbitration, here you can see the word binding decision. In conciliation, the binding thing was missing. So, even if you had concluded something, but it could not be made and it could not be enforced on the parties. That part was missing in conciliation. But in arbitration, here the arbitrator can ask both the parties to actually follow what they had decided. In case of mediation, a mediator facilitates communication and negotiation for a mutually acceptable solution. So the mediator is again a third person. He will ask both the parties to come to a conclusion. He will make that he will make that environment, and he will try to negotiate both the parties to come up to a negotiate mutually acceptable solution. But at this point of time, since the act was not there, I'm talking about the scenario where the mediation act was not there. In that particular case, again, the binding thing was not there. The mediator could not make the other parties bound to perform their promises. So again, that part was lacking, and therefore the Mediation Act had to come into place. Ultimately, litigation, we all understand, parties present their cases in the court, and a judge or a jury decides based on the applicable laws. So that is the litigation, which we all understand. The court proceedings, that comes under litigation. Let us now try to understand the difference in the case of outcome, how this outcome is different in all these cases. So in case of conciliation, parties decide the final terms of the agreement. Conciliator has no authority to impose a solution. So ultimately, whatever has happened, conciliator has no authority to impose that as a solution. He cannot make the parties bound to perform. In case of arbitration, arbitrator's decision is legally binding and enforceable because there is a separate act for it, as we all understand, Arbitration and Conciliation Act. So because of that, it has got its binding force. In case of mediation, I'm talking about prior to Mediation Act, what was happening? Parties themselves determine the terms of the agreement. Mediator does not impose a decision. So in earlier scenario, mediator could not impose that decision, but nowadays after the advent of this Mediation Act, now the mediator will have a power to impose the decision also. In case of litigation, we all understand court issues a legally binding decision. So parties have to follow. So next point of difference would be on the basis of whether there is any prescribed act or rules for this particular thing. For conciliation, often conciliation is often governed by specific laws and regulations in some jurisdictions. Like, for example, in India, we have Indian Arbitration and Conciliation Act 1996. For arbitration, again, it is governed by specific arbitration laws and may have the reference from international conventions also. For example, Federal Arbitration Act in the US, Unilateral Model Law, etc. In case of mediation, though now we already have our own act, but an example is just given. If in the case of American Arbitration Association, they had their own prescribed act or rules for mediation. In litigation, we all understand there is a civil procedure rules, like in UK, federal rules of civil procedure in US, and in India also we have several prescribed acts and rules to govern this litigation. Ultimately, talking about the control, in conciliation, parties have more control over the resolution process and the final outcome because it is up to their choice what they want, and ultimately whether they want to follow or not, it is up to them. In arbitration, parties have limited control. Decision is imposed by the arbitrator. In mediation, parties have a high degree of control over the process and the final agreement. But this was happening prior to the Mediation Act 2023. After this Mediation Act 2023, there will be a change in the scenario. Then what about litigation? Parties have a limited control. Decision is made by the third party, which is judge or the jury. Again, there, if we talk about the enforceability, I think we all have a fair idea now that what is enforceable and what is not. So litigation, whatever the outcome is of the litigation, that is enforceable. So court's decision are legally binding or enforceable. In case of mediation, it could not be enforced earlier. I mean, prior to this Mediation Act, it could not be enforced. In arbitration, they could enforce, and in conciliation, again, they could not enforce it. So, authority of decision maker. What is the authority of the decision maker? Conciliators basically had no authority to impose any decisions. Their role was only of a facilitator. In arbitration, the arbitrators have the authority to make the things binding. So, binding decisions were based on evidence and arguments which were presented. In mediations, earlier, mediators had no authority to impose a decision. They only assisted the parties to reach to a voluntary agreement. But now, after the incoming of this Mediation Act, their role will obviously change. In litigation, we already know that judges or juries have the authority to make binding decisions based on the applicable laws and evidence. So that is how we understand the whole scenario. So we are now talking about mediation, first thing, and litigation. We all understand what is litigation. So if mediation does not come to any conclusion, or finally the outcome of mediation is that the parties are not having settlement amongst themselves, then they finally can, whatever option they have, they can go for it. So IBC is the next option in that case. So what is mediation? Ultimately, we should understand that it is not a replacement. So mediation will never replace IBC. Both the things will parallelly work. So it is a kind of complementary tool. So mediation is only acting as a complementary tool to litigation and arbitration in insolvency resolution. So just to avoid your time consumption in various matters which are going to tribunal and all, if you think the matters can be settled out of court, mediation platform is always there for any of the parties. They can obviously take that approach. And since the Mediation Act is also there, whatever outcome is made available by the mediator, that will now be binding on those parties also. It is not that once they have a mediation, then they can again go for this IBC if the thing have settled. And if the things are not settled, obviously they can go for this IBC. So why mediation matters in insolvency and bankruptcy? So we must understand what are the current issues with IBC. There is a huge backlog in NCLT. 560-day average CIRP resolution time is there versus statutory limit of 330 days. We all know that. There are high legal cost and prolonged litigation. So it's like more than 23,000 cases they are going on. They are pending with the NCLT. So to handle such a huge backlog, actually that is not possible. And just to streamline the process to make quicker resolutions, this is proposed that mediation should be also taken as a tool in the IBC itself. So what are the advantages of mediation? We all understand it reduces time and cost. The whatever discussion has taken place during mediation, that will all be kept confidential. It will not be revealed. And again, it is very much flexible also because it takes care of both the parties. It encourages stakeholders consensus ultimately. So mediation is only, it will be a good thing only when both the parties come to a consensus, or both of them when they agree to a particular thing. Only then it will be beneficial. So what is the global scenario? Again, we have seen this. The Singapore Mediation Center, they have resolved around 80% of the cases within 3 months. In India also, in the case of Lokhandwala Kataria Construction Limited versus Niskas Finance, Supreme Court allowed pre-admission settlement under IBC. So in India also, this concept was existing that mediation was allowed. Anybody could go for mediation. But now we are trying to, formalizing the things because of the all new act coming into picture altogether. So how mediation can be used in different stages of IBC? We must identify this now. So let us assume the first situation where pre-institution mediation is happening, that is before filing CIRP application. So before filing CIRP application, how this mediation can be used. So operational creditors and corporate debtors, they can negotiate before filing a case under section 9 of the IBC. It will ultimately avoid unnecessary NCLT filings and save time and prolonged litigation. So again, one question which arises here is why only operational creditors are given a choice? Why not the financial creditors? Anybody would like to say on this? Any comment from your side? Though it is open for both, but on the discussion paper, as we will see it later also, in discussion paper, it is mainly mentioned for the operational creditors. See, normally, if you ask the financial creditors to go for mediation, will they go for mediation? What do you think? Will any of the financial creditors would agree to mediation? Yeah, so I've got some answer in the chat box. Ramela Rangaswamiji, he has mentioned that financial creditor will not come forward for mediation since public money is huge and so much money is involved. That is correct, sir. Financial creditor will not come forward for mediation. They will not agree for that, obviously. So that is why they have been intentionally not involved. They have not been mentioned here. But even though if they want, I mean, it is up to them because the management decision will have to be there in that particular case. They need answer. Of course, they need to answer to government, RBI, statutory authorities. Perfectly said, very perfectly mentioned in the chat box. That of course they have to reply to the other authorities. It is not one man show in their case. The whole management has to sit together and finalize the things. So it is not very easy for them to go for mediation. Rather, they have a lot of choices. Like in Sarfazi, they can approach that part also, or rather going for this IBC. So they will not opt for mediation at all. So ultimately, that is why, that is the thing, this has not been specifically mentioned for the financial creditors. Now, next we are seeing a scenario where mediation can be used during CIRP. So first part we have seen that it can be used before filing CIRP application. So if operational creditors want, they can first go for mediation. If the things are not settled there, then they can file CIRP application. Now let us come to second stage where even during CIRP, you can have this mediation process going on. So already you have filed an application under section 9 we are talking about. So you have already filed an application, CIRP process is going on, and meanwhile also parties can enter into mediation process. So how it may happen? So resolving disputes between creditors, COC members, or the resolution professional. So if any time any conflict or any dispute takes place between any of these people, they may come together, they may sit together, and they can have a mediation process also. So that the CIP process can go in smooth, or rather they can come out also for from this dispute. This mediation process can again be used for claim verification, inter-creditor disagreements, that can also be used very well in these scenarios. The third stage could be resolution plan approval stage. So when the resolution plan has already been approved, in some cases, if multiple resolution applicants are involved, mediation helps prevent legal challenges post approval. So ultimately, it can be used in various stages. So it is just not that mediation should be, or it can be opted only at the beginning, but whenever required at any of the stages, you can use this mediation. It is open for everyone. But in the discussion paper, they are just mentioning the first stage, that is pre-institution mediation. They are not talking about the other stages because we have already seen that the expert committee has guided to introduce this mediation in a phased manner. They are not introducing it in all the stages of IBC as of now. So it is just proposed to have it in the pre-institution mediation as per the discussion paper, which we will also read in some time. Then last is the liquidation stage. At liquidation stage, mediation can be used for settling creditor disputes during the liquidation process. And we can see one case law also here, JP Infratech Limited. In their case, multiple mediation efforts were attempted to resolve home buyer creditor disputes, but legal battles delayed the resolution. So, if at all mediation could happen in a favorable manner, then this process could have ended up. This process could have easily summed up in very short time. So delays won't happen if a good mediation effort could be put into place at the correct point of time. So what are the key provisions of mediation? Can we go ahead or you want a break at this point of time? Just let me know. Or I think I can take 1 or 2 slides and then we can break for 5-10 minutes. Okay. So at this point of time, when we are again and again talking about mediation act is there, then of course we must understand a few important things. Who can become a mediator? What is the eligibility criteria for becoming a mediator? What are the things which can be taken into mediation act? Because there is a negative list also which is given in the mediation act, that these are some cases which cannot be taken for mediation. So what can be taken into mediation, what cannot be taken into mediation, both the things have to be understood. Then they have this first point, which is reflected also on this slide, that institutional mediation and Mediation Council of India will actually be established for the purpose of this Mediation Act 2023. So ultimately, there will be a separate body altogether, Mediation Council of India, which will look after this mediation process altogether. They will be the regulatory body for this particular thing. Mandatory pre-litigation mediation for commercial disputes. So if we talk about Mediation Act 2023, these are some of the key provisions. We are not taking everything in detail, but yes, we must understand that they have made it mandatory. It is compulsory pre-litigation mediation for commercial disputes. So firstly, we must identify what is commercial dispute, what comes under the category of that commercial dispute. And if it is there, then before filing for litigation directly, it is compulsory that you should first have a mediation. This is what is mentioned in the Act. So it is mandatory to have a pre-litigation mediation. Third point, enforceability of mediated settlement agreements. So this is the basic thing for which this Mediation Act has been introduced. As earlier, the scenario was the mediation, even if it had taken place, the mediator was not having the binding authority. So ultimately, to enforce the decision of the mediator, this has been made very much compulsory that the decisions or the mediated settlement agreements, they will be and they can be enforced under this act. Again, there is a provision of online mediation also. So it sometimes happen, or maybe in most of the times it may happen that the parties are, living poles apart. So one is in the northern area of India and the other is in the southern area. So where to meet, what is the jurisdiction and all. So Mediation Act itself talks about online mediation provisions also. So how will that take place? And all the provisions that they are given, they are mentioned in that online mediation provisions. Then there is a peculiar clause regarding this confidentiality and voluntary nature. Both the things are mentioned, that it is voluntary if other than the mandatory thing, wherever people want, they can opt for this mediation process. Then whatever procedure has taken place, between mediator and the parties, that will remain confidential. That confidentiality clause will be there in the agreement of mediation also. Applicability to corporate disputes. The Act provides an avenue for commercial disputes to be resolved through mediation, including those arising under insolvency and bankruptcy code. So here it is clearly mentioned that any kind of commercial dispute, they can be resolved through mediation. Then next is court-referred mediation. So NCLT and NCLAT can refer cases for mediation to reduce litigation burden. So it is again an option given to NCLT and NCLAT also. They can also refer cases if they want. They can also refer the cases to mediation. So one thing we can understand that the parties are at the option to go for mediation. That is first thing. And again, the NCLT and NCLAT, yeah, I mean these adjudication authorities, they also have a choice that they can refer the cases for mediation. If they think that in litigation it will take a longer time and it will create a burden, they can also ask for mediation. And in most of the cases, they even do that kind of thing. Recognition of mediation institutions. So this will again be a new concept, mediation institutions. The Act facilitates the establishment of institutions that specialize in mediation process, providing trained professionals to handle insolvency disputes. So, like as we are insolvency professional, we were not given any kind of training to handle the disputes as such. So here it is mentioned clearly that the mediator will be given a training and they will be trained professionals to handle insolvency disputes as well.
I think you must request the institute that there should be hand-holding to IPs for these purposes.
Yes, sir. Of course. So not for becoming IP, but again, if you want to become this mediator, then of course, as per the provisions, handholding will be given, or in fact, we have to apply for that training. It will not be known as handholding as such, but again, we have to apply for that training if we really want to become a mediator. Then Patel Engineering Limited versus NEPCO. So this is a case where Supreme Court decided that mediation agreements held, they were made legally enforceable. So whatever mediation agreements were there, they were made legally enforceable in this particular case. So what is the role of insolvency professionals in mediation? So here comes our role basically. So first is the advisory role. Firstly, as our clients or the stakeholders are not aware about this new concept of mediation, it is our duty to make them aware, to tell them that there is something which is known as mediation. So you can go for out of court settlement also. And we are ourselves asking our clients to go for mediation. So advisory role, it is basically to educate the stakeholders about the mediation. Then second is facilitators of mediation. So helping the creditors and the debtors negotiate their settlements. So you can again help them out to negotiate and settle their disputes. Then ensuring compliance, keeping mediation within the IBC timelines. So again, the timelines have to be adhered as we are talking again and again about it. So ensuring compliance is one of the key concerns, should be one of the key concerns of the insolvency professional. Then next is acting as a mediator. So IP can act as a mediator if he is certified, or maybe if he has the proper, if he is actually qualified as per the Mediation Act. The qualification we will study there, how a person can be called as a mediator. So basically, we should understand, we cannot say that, okay, I have good skills to become a mediator. So even though I have not been, recognized by the act as a mediator, I can still become a mediator. It will not be like that. So for becoming a mediator, you should be firstly eligible to be a mediator. Then secondly, you should have qualified to become a mediator as per the norms which are given in the Mediation Act for that. Otherwise, it is not that you can call yourself as a mediator. It is not like that. Okay, I missed one thing. Okay, UK pre-pack administration. This we have already understood that mediation there helped resolve disputes between the creditors and prevented company liquidation. Here, the importance of mediation training for IPs to become certified mediators is very important, as Sir has also rightly mentioned. But again, don't know. I don't think the institutes will come up doing this thing. Maybe CS Institute or CA Institute, where they have a separate thing for the IPs. There they may come up with their training sessions or maybe exclusive plan for making IPs do this particular course for mediation. But as of now, there is no such thing which is available. Okay, step-by-step guide to avail mediation under IBC. So we are talking about pre-institution mediation, that is before filing Section 9 application, how should you go about it? So the operational creditor will initiate the mediation. He will try to, or they will try to attempt the settlement. If the settlement fails, then they will submit a non-settlement report with the CIRP application. So now this has been made compulsory, this non-settlement report. So non-settlement report will be issued by the mediator. So the Section 9 application will have to be accompanied with this non-settlement report. So firstly, we should understand that if you want to file an application under Section 9, it is purely voluntary whether you want to go for mediation or not. So if you had gone for mediation and the ultimate outcome was non-settlement, then in that case, a report will be issued by the mediator and the report shall be filed along with the Section 9 application. And the result would be like, now the NCLT will not allow further time for the parties to go for mediation. So it is curbing that particular time. So ultimately, as we studied earlier also, that NCLT and NCLAT also have an option to ask the parties to go for mediation. But now, when it comes to them that the parties had already taken this option to go for mediation and they could not settle among themselves, so it's better not to allow them further time for mediation. So, likewise, the process will become smoother. So, that is the thing which I mean that is being proposed here. Next is mediation during CIRP. So during CIRP, how does it take place? So if there is a dispute among the creditors, this can be referred to mediation. So you should understand at what point of time mediation can happen or mediation can take place. You should understand, being an insolvency professional, you can always guide your clients or the stakeholders to go for mediation because you cannot solve out each and everything. You also want to finish off the things in time. So you should understand what are the various options which are available. Next is resolution plan approval mediation. So it is used to negotiate competing resolution plans. So if the parties are not convinced by you, then in that case you can have a third party as a mediator and make them negotiate the terms amongst themselves. That can happen. Then in liquidation stage, creditor disputes mediated before finalizing liquidation. Then in JP, we have already studied this case that there they tried this mediation process. So now the question arises how to become certified mediator, because once you are a certified mediator, then only you can go for, then only you will be considered as a mediator, and then only you can go for mediation proceedings. So what is the eligibility criteria as per Mediation Act 2023? So firstly, a person should have experience in law, finance, or insolvency. So even if a person is not an insolvency professional, they can still become a mediator. The eligibility criteria here simply says that they should have experience in law or finance. How many years of experience and all, that is mentioned in the act or the regulations there. So if we want to have detail, we can open that act also and we can check it out. Then next is completion of certified mediation training program. So it is not just that you should have experience in a particular category or a particular field. Then you have to pass an examination or you have to complete a training program also. So it is again here mentioned that they have to complete a certified mediation training program. So whatever institutes are there who are which are providing this certification courses on mediation, if you have done any of those courses, then you may be considered as a certified mediator. But again, wait, the third part here is you should then be registered with the Mediation Council of India also. So it is not just having experience. That is just the first thing. That is the entrance point. Second is you should have this training program also. You should have done a certification course also. Then the third thing is you should be registered with the Mediation Council of India. Then only you will be considered as a certified mediator. And if you want to go it or you want to drill it down further, we can open the act also and we can read out the provisions. Then what about the training and certification program? Because that is the only question which will come to anybody's mind, that okay, I have the experience in law or finance or insolvency. Then where to go for this training or certification programs? So institutes offering certified mediation training such as IIAM, NEL, SAR, and ICI. In ICI, this arbitration and conciliation mediation thing, a certification course is there for that particular thing, but it is not specifically for mediation, I guess. So if they have said, I mean, that part is still to be made more clear, what kind of certification program or whether there will be a separate certification course altogether. So right now, what they have mentioned is that you can enter into any of these training programs which are conducted by these institutes. You can do that, and but still everything is not very much clear. Even if you do these courses, ultimately you should be registered also with this Mediation Council of India, which is not yet formed. So Mediation Council itself is not there as of now. So even if you try and do these trainings, that is of no use. So you cannot act as a mediator. Then accreditation process. So what is the process? First, you enroll in any of these certification courses. Then you register with the Mediation Council of India. Then apply for empanelment with NCLT or NCLAT as an insolvency mediator. So ultimately, again, being an insolvency professional, we are going for empanelment, and for this also you'll have to go for empanelment. Okay, like in case of Delhi High Court Mediation and Conciliation Center, they have trained around 1,000, more than 1,000 mediators for commercial dispute resolutions. So hats off to them. They have done this thing, but the door is still open for all of us, and still the scenario is not very much clear. So we should wait before directly jumping into doing this kind of process. So what are the challenges and the road ahead? Uh, I can take this slide also, and then probably we can have a break. So what are the challenges? The first challenge we see here is that there could be a resistance from the creditors and stakeholders due to lack of awareness. So you cannot push them to go for mediation, even though that will reduce their time, and that things will become quick. But still, because of lack of awareness, they will try to resist. And again, it's our duty to make them aware. If it is fruitful with them, we should try to make people aware. Then ensuring IBC timelines are met without unnecessary delays. Obviously, that is because on papers it says that it should be done within so much time. And let me just tell you all that the mediation process, there they have given a timeline of 120 days, which can be extended by 60 days. So again, 180 days criteria is there for mediation, and if it fails, then then you can proceed for IBC. So 180 days already wasted, and then again you are going for IBC. So we should try to reduce the unnecessary delays if at all it is happening. So need for more trained insolvency mediators with domain expertise. So that is the crux which we must understand, that training is actually necessary for becoming good insolvency mediators now. Limited institutional support for mediation under the existing IBC framework. This we all know because it has just come up. So institutional support is obviously not available. So it will take time. We are still saying that the IBC is also evolving. So let's see how long it takes for mediation to develop altogether. So what is the future roadmap? Integration with IBC regulations for mandatory mediation in selected cases. more awareness among creditors and IPs through training and seminars, IBBI initiatives for formalizing mediation process under IBC, development of specialized mediation centers for insolvency disputes, and this we can easily understand that if we are able to handle all this thing, then obviously we can also sort out, I mean, around 50 to 60% of cases which they can go out of court settlement. We can have a break now. Uh, uh, Someone has asked a question in the chat box. Let me take up that. During CIRP or liquidation, who will initiate mediation? Is it allowed under IBBI? Anyone can take up mediation. It is just that our role is to suggest that mediation is possible. That is the only thing. And if you actually want to do mediation, the process is mentioned in the act, Mediation Act, how to go about it. Firstly, let us understand the steps. During CIRP or liquidation, being an insolvency professional, it is your duty to guide the parties that they can even go for mediation. If a lot of time is, taken in the proceedings of NCLT or NCLAT or wherever. So it is given there. IBBI is coming up with these guidelines for mediation. It has just given one discussion paper. The things have not materialized as of now, but sooner or later we will have the regulations for mediation as well. Though it is voluntary, but still regulations will come up in future. Coming future, we will have this. We can have a short break of 10 minutes and then we can assemble around 4.
Sure, madam. Sure.
Okay. Thank you. Can we start?
Yes, ma'am.
Okay, I will just share my screen.
Yes, madam.
Talking about these challenges and the road ahead. Now I think it's time to understand the discussion paper, which we are talking again and again. The discussion paper on mediation by operational creditors before approaching the adjudicating authority for filing Section 9 application. This is the heading of that discussion paper, why this is there. So they are saying that mediation can be done by operational creditors before they are approaching to adjudicating authority for filing Section 9 application. So that is it. And let us see what are the provisions or what are the contents of this discussion paper. So this was issued on 4th November 2024. It was open for 1 month for the comments. Now it is not open for us. It is already into their hands. IPB will now set the procedure or the guideline based on the comments which they have received. So it clearly says that it is a voluntary mediation. So mediation will be voluntary. It shall not be made compulsory at all. Then when they are mentioning this thing in the discussion paper, they highlighted a few issues in Section 9. So what are the common issues in Section 9 application? First is there is disagreement on goods or services regarding the quality or the performance of goods and services provided. Second, there are issues related to contractual disputes, having allegations of non-compliance with contractual terms by either of the parties. Third issue could be this discrepancy over the exact amount owed or alleged underpayment. Fourth, issues regarding claims of corporate debtors against the operational creditors for set-offs or damages. So all these issues, if you can see that they can be sorted out if both the parties, sit at one place and talk with each other. So thereby they are saying that these kind of issues can be handled by mediation itself. Out of court settlement will be a better solution if these parties are cooperative enough to sit and just discuss these things. So these issues are time consuming and create unnecessarily burden. uh, they actually burden the limited judicial capacity which is there in our country. So ultimately, therefore, they are saying that we should go for mediation. But let me ask you one thing. While filing this Section 9 application, there is something regarding dispute word. Whether a disputed application can go to this NCLT Section 9 application, can you file if there is a dispute? Can we file an application under Section 9 if there is a dispute? Someone has replied. So Ajay sir is saying no. So we all understand that if there is a dispute, we cannot go for this Section 9 altogether. Then why we are talking about mediation? Mediation will take place only if there is a dispute or if both the parties are agreeing to a particular thing. Then why will they go for mediation? So what is the concept behind this mediation if we are talking about Section 9 application? Any idea? Are you getting my point? I mean, we can file Section 9 application on only when the case says that they are not having any kind of dispute. But if we are going for a mediation, there is a presumption that there is a dispute and therefore we are sitting together to settle that, right? So if the mediation process is successful, obviously you are not filing this application. But if the mediation process is unsuccessful, this will certainly mean that both the parties are at some or the other dispute, aren't they? That is why they could not resolve their issues during the mediation process.
I mean, even if there is a no dispute,
Yes, sir.
so say I have a dues of 1 crore, so the party is
Right,
saying
sir.
50 lakhs just to a settlement.
Right.
So there was no dispute. So still I can go for 9 application.
Yes, sir. That is actually, some people are confused with this particular thing, that if you are going for mediation, it itself means that there is a dispute. And when we say that, because there is a prior condition here, that while you filing the Section 9 application, and if you had earlier gone for mediation, you have to submit that non-settlement report given by the mediator. So that non-settlement report, will that amount to saying that, or will that evidence, that will it become an evidence that there was a dispute? So for that reason, I'm asking it again and again. Again, one more thing, we should understand that there is a clause of complete confidentiality. Whatever is being discussed during the course of mediation, nothing will be, nothing will be put on the table of while filing the application of Section 9. So NCLT will not be given any factual description what happened in mediation. So we should be all made very much. I mean, this thing should be made very much clear to ourselves that if anything at all is happening during mediation, then only a single liner report will be given whether the thing has settled or it has not settled. So if it has not settled, that will only go to the NCLT. We are not saying that there was a dispute or there was not a dispute ultimately. Fine. So again and again, we are pondering on this particular point that even if there is a dispute, I mean, parties are very much settled that we have to pay something, but we don't want to pay it full. That is the only thing. So it might happen that the quality of the goods was not as per our wishes or whatever. So we don't want to pay the other party the full amount. That is the only thing which is bothering them. So if these kind of things can be settled out of court, so it's better to go for mediation. That is the whole concept we are talking about. So we are not saying that if you are going for mediation, it indirectly means that you are at dispute. We are not saying that thing. Okay. So I request you all, please kindly mute yourself. Kindly mute yourself. Anjali ma'am, please can you mute everyone? Yeah, thank you. Thank you. So mediation can be taken as an effective tool as per the discussion paper. So here they are saying that operational creditors are more interested in repayment of money claims rather than admission or resolution of corporate debtor. So they are more interested in, repayments rather than going into the admission or resolution. Normally, practically, which is happening, the things which are happening is operational creditors are trying to file this Section 9 application just like a arm twisting technique, so that at least we will have our money back. So that kind of things are also happening. We all are aware of that thing. So ultimately, their intention is not to take the other party to, CIRP proceeding. They don't want them to lose the control over their business, or, shut down their business or whatever. They just want their money back. That is the whole intention is. So ultimately, it is mentioned here also that operational creditors are more interested in just their repayment of money claims rather than taking the other party, or rather than taking the corporate debtor into CIRP proceedings for admission or resolution, etc. So according to the adjudication authorities data, now we are talking about some statistics which is updated till 30th April 2024, because this was mentioned in the discussion paper. I have taken it from there only. So the data as per adjudicating authority, it is saying that cases under Section 9. So cases under Section 9, how many cases were admitted? Up to 30th April 2024, around 21,466 cases were being admitted. Sorry, they were the applications which were filed. These are the applications which were filed. 21,466 are the applications which were filed. And finally, how many cases were admitted? So it's a mistake from my side. I could not write it properly. So applications filed are 21,000 something, out of which cases actually admitted are only 33,818 only. So around 10 to 12% we can say that these much cases could only be admitted. What about the rest of the cases? So around 80% of the cases, what has happened to them? 80 or maybe more than that, 85% of the cases, what has happened to them? They could not be admitted, either they were rejected or the applications were withdrawn. So ultimately, what is the analysis? Mostly these applications were settled before the admission itself. So the difference of these applications, you can very well make that out. Around 17,000 applications, they were settled before admission itself. Settlement rate of CIRP pre-admission for operational creditors has been larger at any other stages. However, the adjudicating authority is required to conduct hearings before accepting or rejecting an application, and the process often becomes time consuming. So because you have already filed an application, adjudicating authority is bound to hear those cases, even if you are in the process of withdrawing that particular case, or you are doing some out of court settlement or something. So since the application is lying with them, it becomes burden for the adjudicating authority. So that is why they are saying that uh, ultimately it should be made a choice for the operational creditors, that if they really want to uh, settle the cases out of court, it should be done before filing the application itself. Thus, in order to resolve the disputes between the operational creditors and the corporate debtor at the earliest stage and facilitate faster admission by the adjudicating authority, mediation as an option may be considered as an effective tool. So what is the proposal for the new CIRP regulation 2BA? So this is there in the discussion paper. Finally, the discussion paper talks about this, that they are in the process of, IBBI is in the process of inserting a new regulation. Regulation number will be 2BA. In the CIRP regulation, this will be something new. So this is the language of that regulation which they are proposing. Let us read it. An operational creditor may undergo mediation with the corporate debtor for resolving the disputes of commercial nature in accordance with the provisions of Mediation Act 2023 before filing application under Section 9, and thereafter file the application under Section 9 along with the report of the mediator. I'm sure there are many things which you would like to, focus upon or emphasize upon, or you want to read that again and again. So we are having a proper analysis of it, step by step, or words we will take, and then we will analyze. So firstly, it starts with an operational creditor, right? So I have just taken for whom this particular regulation is applicable. So this is applicable for an operational creditor only. So this proposal of mediation is for operational creditor only. This is the first thing. So again, this operational creditor has a choice. So the word may itself denotes here that he has a choice. So operational creditor has a choice that he may undergo mediation with the corporate debtor. He has a choice to undergo mediation. So uh, who is who on whom this regulation is applicable, and what is he supposed to do? So he's supposed to go under this mediation process with the corporate debtor for resolving the disputes of commercial nature. So again, there are a few things to be understood at this point of time. So here IBBI is saying that we want operational creditor to undergo mediation to solve disputes. But what kind of disputes? Disputes related to commercial nature. So again, this is a new term which we must understand. What do you mean by commercial nature? Because this term is not there in IBC, commercial nature. So for this, we have to take the reference from Mediation Act. And again, in Mediation Act, they have not discussed this thing, and this will take a reference from some other act. So let us go further. in accordance with the provisions of the Mediation Act 2023. So, okay, till here we understand that operational creditor has a choice to undergo mediation with corporate debtor for resolving the disputes of commercial nature. And if he actually wants to go into mediation, he has to follow the process which is given in the Mediation Act. So he has to follow the provisions which are given in the Mediation Act 2023. So here IBC is having the whole reference from the Mediation Act. So if at all you want to go for mediation, you have to follow the provisions which are given in the Mediation Act 2023. When this all thing should be done, or this mediation process, when do they want you to do this? They want it to be done before filing application under section 9. So if you really want to have a mediation, do it before filing application under section 9. This is what is being mentioned in the proposed regulation. Though otherwise also the option is open. I mean, at later stages also you can go for it. But for the time being, the regulation says that you can go for mediation before filing section 9 application. And if you have gone into that mediation, then file application and it has not settled. So this point says that if the things have not settled under mediation, then you can further go for application under section 9 along with the report of the mediator. So here you have to take the report of the mediator which says that the things have not settled. So along with the application of section 9, you have to file this report if at all you have gone into mediation, so that NCLT will not allow you further time for the mediation, and thereby they will adhere to the timeline which is given in the IBC. So what are the salient features? Let us understand. The salient features are regarding this Mediation Act. We will take that act itself directly. Okay, from here, let us understand what is the preamble to this. So before I go into this Mediation Act, let us have some views about this discussion paper, which talks about this new regulation. Are you all in favor of having this kind of regulation in CIRP?
1223.
And this may increase the legal, cost on the operational creditor. Maybe the small one may not find it, if they have to go to NCLT also, mediation fails.
Yes, sir. So again, before going to mediation, we have to analyze. Like in income tax nowadays, don't we analyze which regime is good, old regime or the new regime? So you analyze both of them. So it's double working for the professionals, obviously. The fees will remain the same and you'll have to work it out. And then you have to suggest the things which is good for the client ultimately. So this is how this will take place. And ultimately, whosoever is becoming a mediator cannot become the insolvency professional. That will obviously come sooner or later. Though something is there in the act itself, in the Mediation Act itself. So clarity will be given in the IBC also. So,
But
okay.
ma'am, will
Thank
it
you.
be, I'm not sure. Suppose there may be small operational creditor or maybe large creditor. So will it be for both the operational creditor?
So everything is, it's as at this point of time. I mean, it is choice given to any of the operational creditor. It is mentioned that an operational creditor can go. It's not that all of them have to go for that particular thing. It's not COC, sir. It's just before filing the application.
No, will it be a prerequisite before filing Section 9 application?
No, sir. It's again a choice. No, it's mentioned here. An operational creditor may undergo mediation. We will read the Mediation Act also, sir. Mediation Act says there is a threshold if you are going there. In some, like if you had gone through the earlier slides, I had mentioned that Mediation Act talks about something which is mandatory, where you have to take mediation compulsorily. So there are a few cases where you have to take mediation compulsorily. So there is a separate threshold limit and things related to that. We will talk about that also, sir. But here in IBC, they have clearly mentioned that if the case is of commercial nature, then again we have to understand what is commercial nature dispute. So if at all there is a commercial nature dispute, to resolve that, you can go for mediation. But if it is crossing that threshold limit which is given in Mediation Act, you have to actually go for mediation. That is the ultimate conclusion. Am I clear, sir, on this part?
Yes.
Okay. So any other comment from anybody whether this uh, insertion of new regulation, will that be beneficial for us, or it is just uh, something which is making the things more complicated? Anybody else? Your views are very, very important, because actually if this session had taken place around November or so, then you would have given your comments or suggestions to the board also. But now we are too late for that, but still we can do the brainstorming whether or how we should take it forward. If at all this will come into the regulations, how we should go about it. Should we analyze each and every client whosoever comes to us, or we should just hide the facts that there is something called mediation and we should directly ask him to go for IBC?
Ma'am, commercial nature you said is not defined.
Yes, sir, it is not defined here. We will have to check from the Mediation Act only, sir. We will check that, sir. So I am just proceeding there only. I think this we can skip. We are taking directly the preamble of the Mediation Act. So the preamble of Mediation Act, it says that it is an act to promote and facilitate mediation, especially institutional mediation. So this is a new term for all of us, institutional mediation. So normally it is for the corporates and all, mediation will be for them. Normally we understand that mediation takes place between two individuals. So now institutions are involved, corporates are involved. So it will be an institutional mediation. That kind of thing we can make out here. For resolution of disputes, commercial or otherwise. So here, if you can very well see that the Mediation Act says that it is the object for mediation is to resolve disputes, commercial or otherwise. So even if it is commercial or not, both of them can be taken in mediation. But in IBC, the regulation which we just saw, it clearly mentioned that only commercial nature disputes they are given an option to go for mediation. So that is what they have mentioned. So they have actually created some kind of confusion. Why only commercial? Why not others? So it is, some people are of the view that the commercial term which is there in the let me take you to that analysis. Yeah. So here it is mentioned that commercial nature. So we should not have this commercial nature term altogether. We should just have this term. We should have it till here only for resolving the disputes. It be of whatever nature, because Mediation Act does not restrict anything. Then why IBC is restricting? So that may be one of the views. So it now again it was open for discussion and people have commented for that also. So as of now we are told that this commercial nature word is there in IBC. They have proposed it here, but in mediation it has a wide scope. It not only includes commercial nature disputes, it includes the otherwise disputes also. So what is there in the preamble? Let us read further. To enforce mediated settlement agreements. See, read all these highlighted words. These are very, very important. So as we understand, the object of bringing this Mediation Act was to have some kind of binding force, to have the settlements take place. Actually the parties should not differ from what they said earlier, so they should stick to what they agreed to. So therefore, to enforce mediated settlement agreements, again this term will be defined also. What do you mean by mediated settlement agreements? In short, it is just that whatever mediation has take place, whatever settlement has take place, so they have taken it down, they have reduced it into writing, and therefore they have created an agreement which is simply known as mediated settlement agreement. provide for a body of registration of mediators. So this is another object. So this Mediation Act will lead to a new it will lead to an introduction of a new body altogether for registration of mediators. Till now there might not be any registration required for the mediators, but now on, if you want to say that you want to work as a mediator, then you have to get yourself registered within the body as the mediation council, the name which we recently saw, that mediation council will be there, and there you have to get yourself registered if you want to be known as a mediator. And ultimately, the object is to encourage community mediation and to make online mediation as acceptable and cost effective process, and for matters connected therewith or incidental thereto. So, with all these highlighted terms, the whole idea of bringing this Mediation Act into existence was there. So they want to have a mediation facility. They want to have an institutional mediation. They want to resolve all kind of disputes, whether commercial or otherwise. They want to have a mediated settlement agreement and to make it enforceable also. Then they want to have a body of registration of mediators. Then they want to encourage community mediation as well as the online mediation. So all these terms which are, which are seeming to be new also, somewhat, they will be discussed in detail in the definition part, obviously. So what is the applicability? It is mentioned in section 2. This act shall apply where mediation is conducted in India. So again, the jurisdiction is defined here. Mediation Act is applicable only where mediation is conducted in India. And so the place is one of the things. And secondly, it has several other conditions along with it. So the first thing, the applicability of the act is only and only in India. If the mediation is taking place in India, then only this act will be applicable. First thing is that. And besides that, there are other conditions also. The first one being all or both parties habitually reside in or are incorporated in or having their place of business in India. So either both the parties are residing in India or they have a place of business in India, or the mediation agreement provides that any dispute shall be resolved in accordance with the provisions of this act. So till now you might not be having any agreement which had this particular clause, but now onwards, since this is a new act, so it is required to be inserted in new agreements that in this kind of mediation clause should be there. So if there is a clause, then obviously this act will be applicable. Then there is an international mediation. So again, if mediation is conducted in India, whether it is international mediation also, on that also this act will be applicable. Wherein one of the parties to the dispute is the central government or a state government or agencies, public bodies, corporations, and local bodies, including entities controlled or owned by such government, and where the matter pertains to a commercial dispute. Okay, so for this fourth point, you can see here, even the government bodies, on government bodies also, this act shall be applicable. They can also enter into mediation, but only for the disputes related to commercial nature. See, the wider scope of Mediation Act is for other parties, but if it is a government body or any government agency, in that case, the scope has been restricted. It is only for the commercial dispute that they can enter into mediation. To any other kind of dispute, if deemed appropriate and notified by the central government or state government from time to time, for resolution through mediation under this act. So there will be a separate list which will be prescribed, obviously, what all disputes can be taken here, wherein such government or agencies, public bodies, corporations, and local bodies, including entities controlled or owned by them, is a party. So if any one of them is a party, then also that kind of dispute can be there if it is prescribed. So non-applicability is also mentioned in this particular act. So on what cases mediation will not be applicable? This act shall apply when mediation is conducted in India, and this we have already understood. Here, Section 6, disputes or matters which are not fit for mediation. So it is mentioned clearly in first schedule what all cases cannot be taken into mediation. So like disputes involving prosecution or criminal offenses, they cannot be taken into mediation. Disputes relating to claims against minor deities, persons with intellectual disabilities, etc., they cannot be taken into mediation. Disputes which have the effect on right of third party, except matrimonial disputes, disputes under National Green Tribunal Act, and so on. I mean, there is a complete list which says that uh, these kind of disputes cannot go into mediation. So, in nutshell, if there is a separate act for particular case, then they will not be taken here. If the matter is involving any criminal offense or any prosecution, that will not be taken up for mediation. If it is for collection of any tax or penalties, then also it will not be taken for mediation. What is the time period prescribed for mediation? So here it is mentioned that Section 18 of the Act provides that mediation proceedings must be completed within 120 days from the date of first appearance, or for an extended time frame of 180 days if agreed upon by the party. So it is 120 plus 60 days. In total, it is making to 180 days. So that is the time period which is mentioned here. What is mediation agreement? A mediation agreement may be in the form of a clause in an agreement or a separate agreement as long as it is in writing. So first and foremost thing, mediation clause or mediation agreement has to be reduced in writing. It cannot be oral. Is there anyone asking anything? How many cases have been registered and resolved through Mediation Act in India since implementation? Is there any statistical data available? No, sir, there is no data as such, because mediation after this introduction of Mediation Act, still the council is not there, sir. So unless we have the council, there is no specific data related to this particular act. However, whatever is happening is under that Arbitration and Conciliation Act that you can check out, but not specifically for mediation. The Mediation Act explains in writing to mean either any document signed by the parties, or an exchange of communication or letters, including through electronic form or as provided under the Information Technology Act, or any pleadings or any other proceedings in which existence of mediation agreement is alleged by one party and not denied by the other. So it is just saying that mediation has to be in writing. Only then you can go for this mediation. But again, if through any proceedings also any term, this term has been highlighted that you can go for mediation, that will also amount to a mediation agreement only. So that is what they are interpreting here. Further, parties can submit a dispute to mediation even subsequent to dispute arising between them. So even if after having the mediation, they may still have some other kind of dispute which they can go for. So what shall be the flow of mediation process? This is the complete flow. If it is visible to you all, I mean, okay, so it will start from here. Agreement by the parties. So firstly, they will appoint a mediator under Section 8. Then 7 days from the notice of the appointment, mediator has to communicate his willingness to become as a mediator. So just like in case of insolvency profession, also we have to give our consent. If you are an auditor, then you have to give your consent. So likewise, 7 days are given from the notice of appointment, whether you want to take up the assignment of a mediator or not. And then as soon as this notice is given to you, commencement of mediation takes place. So when as soon as you are appointed, the commencement of mediation starts, because that time period will be excluded. The date of commencement of mediation till it has completed, that time period will be excluded from the limitation period. So next, first appearance before the mediator. So mediator may ask both the parties to come together and talk about their differences. So this may take up to 120 days, and this can be extended for further period of 60 days. Then on completion of mediation, which is provided in section 18, how and when it is called completion. So there may happen two situations. Either there is a settlement between the parties or there is a non-settlement. So if there is a non-settlement, then a report shall be prepared by the mediator under section 21. And if this has settled, so mediated settlement agreement will be prepared. So whatever terms and conditions they have agreed to, that will be, reduced into writing, and that will be known as mediated settlement agreement finally. And then after that, this can again be challenged. It is saying that if you really want to challenge this also, you can go for it. And within 90 days, you can go for challenging this mediated settlement agreement. Then voluntary registration, if otherwise you can go for this voluntary registration of this particular settlement agreement. So this is how it is taking place. There is another thing which is mentioned here, application to mediation service provider. So if parties have themselves appointed a person, that will be a mediator for them. Otherwise, they can give an application of appointment of mediator to mediation service provider. So there is a new term, mediation service provider. Who is a mediation service provider? We'll see the definition in a short while. So if you yourself don't have any idea who is the mediator, you can ask the mediation service provider to give you a mediator for the proceedings. So that is how it will go ultimately. And the replacement option is also there. Termination of mediator, the mediation process is also there. At any point of time, you can opt out from this mediation proceeding. Again, the definitions, key definitions which we must understand are given under section 3. So 3H basically talks about what is mediation. So mediation includes a process whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, then conciliation or an expression of similar import. So any kind of similar nature or any kind of mediation will be included as mediation here. Thereby parties, so what should happen in that particular scenario? What do you mean by mediation? They are trying to explain it here. Thereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person. So again, they have clearly mentioned that there will be an involvement of a third person here, referred to as a mediator. So again, mediator will mean mediator appointed as per this act. So you cannot understand mediator any person. So there is a proper definition who is a mediator, which is mentioned below. So appointment of this third person will be there to assist to reach to a amicable settlement of this dispute, and who does not have the authority to impose a settlement upon the parties to the dispute. So he must be an independent person. He should not have any kind of authority on those people. Then understanding the meaning of mediator, 3I, 3 clause I, it says that mediator means a person who is appointed to be a mediator. So maybe direct appointment letter is given by the parties to him, by parties or by a mediation service provider. So who can appoint a mediator? Either he can be appointed by the parties themselves or he can be appointed by the mediation service provider. So just in the previous flow chart, we saw that if the parties are not aware about any mediator, they may approach to this mediation service provider, and in turn, this mediation service provider will appoint a mediator for them. So they have a panel of mediators with them. So they have a complete list of people or the persons who will be regarded as mediator to undertake mediation, and includes a person registered as mediator with the council. So it also, mediator will include a person whosoever is registered as a mediator with the council. So right now we don't have the council as such, so the registration is also not there. So that is the thing. Who is a mediator? This is how a mediator is appointed, or ultimately this is the person who will be known as mediator. Explanation: where more than one mediator is appointed for a mediation, reference to a mediator under this act shall be reference to all the mediators. Okay. Mediation agreement. What do you mean by mediation agreement? it simply means a mediation agreement referred to in subsection 1 of section 4. So ultimately, we'll have to understand it in the later sections. What is Mediation Institute? It means a body or organization that provides training, continuous education, and certification of mediators and carries out such other functions under this act. So again, mediation institutes will be set up, or already institutes which are giving these kind of certificate courses, they will be, accredited by the council then. So as to continue this kind of service, giving continuous education services, etc., certification, etc. Mediation service provider. So this is a new term. Mediation service provider means a mediation service provider referred to in subsection 1 of section 40. So we will see that later. Just a second. It will be coming in the next slide. The section 3N, mediated settlement agreement. It means a mediated settlement agreement which is referred in section 19.1. Then international mediation. This is an important term. This is a new term, in fact. And on international mediation also, we just read that Mediation Act is applicable. So international mediation means mediation undertaken under this act and relates to a commercial dispute arising out of a legal relationship, contractual or otherwise, under any law for the time being in force in India, and where at least one of the parties is an individual who is a national of or habitually resides in any country other than India, or a body corporate including a limited liability partnership of any nature with its place of business outside India, because international should mean some one of the parties is coming from outside. So outside India, either if it is an individual, either of the parties, one of them, I mean, should be having a different nationality. Then in case of body corporates, the place of business should be outside India. Either of the parties' place of business should be outside India. Then an association or body of individuals whose place of business is outside India. In case of government, because government can also be a party in this mediation, then if it is a case of government, the government of a foreign country will simply be considered here in the international mediation. So now the question arises, because we can take this at length also. We can open that act and see a few provisions which will be easier for us to understand. But just a quick question which comes to anybody's mind at this point of time: how you can increase the acceptance of mediation in IBC cases, how you can create the awareness, how you can actually make people understand that mediation could be a better approach. So the first and foremost thing, a kind of solution here is there has to be a regulatory backing and integration into IBC. So that is why IBC has come up with this discussion paper that let us give a choice to the operational creditors that they can even go for mediation. If they had not come up with this approach, then obviously mediation would not have been of very much effect. So a regulatory backing is required, and integration into IBC will obviously be helpful in reducing the timeline and ultimately reducing the burden of the NCLT. So mediation should be mandated at key stages of insolvency resolution, though they have not mandated it, but it will be tried in the phased manner. So right now they have given an option only. So it is just a suggestion that they can even make it mandatory to do that, but let the committee decide how they want to take that up. Amend IBC to formally recognize mediation as a dispute resolution mechanism alongside litigation and arbitration. So that can also be a possibility. That can also be something which can be done, but I think that will take time. The second point here could be awareness and training for the stakeholders. Now, how to train the stakeholders? That is a very difficult thing. We can at least, we can train the insolvency professionals. We can keep sessions for them, but how to train or make the stakeholders aware? So educate creditors, insolvency professionals, and business about the mediation's benefit through seminars, training programs, and workshops. So what can be one of the suggestions is being an insolvency professional, you can yourself take training sessions, or you can organize some kind of seminars or workshops where you can guide the stakeholders regarding this thing, mediation process and its benefits and all. Law schools, business schools, and IBBI should incorporate mediation in their curriculum also. So that is why you have your new syllabus for this insolvency examination. Therein, they have incorporated this Mediation Act already. Third solution or third way to increase the acceptance of mediation, institutional support and mediation infrastructure. So to establish dedicated insolvency mediation centers, which are linked with NCLT and MCLAT, encourage formation of panels of trained insolvency mediators empaneled with the court. The next option could be incentives for mediation. Obviously, this will this will actually boost the mediation process if there is some kind of incentive. So provide cost and time benefit to the parties opting for mediation, offer fast track approval for resolution plans, which can be settled via mediations. But let us see how these things take place. Then next, with the technology also, we can leverage the technology also here. So technology driven online mediation should be approached for that. So promote online mediation platforms for faster and more accessible dispute resolution. Use AI based tools to streamline claim verification and settlement discussion. So these are just suggestions, but how the things will go, we can wait and watch for more things in the coming future days. We will see some more new regulations or new guidelines from the institute itself. So I think from the PPD point, I am done. If you really want, we can start with that Mediation Act. How many of you have actually checked that out for yourself? What is Mediation Act? Anybody? Anybody who has checked out what is there in the Mediation Act? How many sections are there? How many schedules are there? If not, then it's the opportunity. We all can read that together. I'll just open it from my side only. Just give me 1 second. So it's a very small act containing 65 sections. Just a second, it's still opening. Is it visible?
Not yet.
Not yet. Okay. Just let me try once again. Is it visible now?
Some files are opening.
From my side, it is visible. Just check it again if it is visible now.
Act is not visible. Your Windows is visible.
Already the grid is only open. You have to open the file.
Sir, from my side, I have already opened. Is it not visible at your end? Let me try
No,
that.
no, madam, no, it's not open.
Okay, okay.
I would suggest you to open the site India Code.
So
And
from
then
there
you
only, I have downloaded already. So that is why I'm just checking.
go
Is
for
it
the India
visible?
Code.
Is it
Okay.
visible now, sir?
Now,
Yes,
yes,
it is
visible,
visible now.
visible.
It is visible. Okay.
Yes,
Fine, sir, fine. Okay. So we'll just quickly walk through it. So you can see here the name of the act is the Mediation Act 2023, and on 14 September 2023 it was introduced, and though the commencement date is 9th October. And here we can see it shall come into force. So okay, the date we have already discussed. Then how many chapters are there? We will just quickly see what all sections are relevant for us. This is the application part. This act shall apply where mediation is conducted in India. This part we have already taken in our presentation. So first thing is mediation should be conducted in India. Only then this act will be applicable, plus any of the following conditions. So India, the mediation process should be conducted in India. That is the first condition. And the second condition could be any of these. So it is related to the person, where that person is living or his place of business is there. So accordingly, that is the application criteria. Then we have these definitions. So commercial term was coming into. So commercial dispute means a dispute defined in clause C of subsection 1 of section 2 of the Commercial Court Act 2015. So again, a reference is given to Commercial Court Act, and there they have suggested 21 kind of things which are considered as commercial dispute. We are not going into that detail, but again, this is not defined here, but it has given a reference to the Commercial Court Act. Then a few definitions we have already taken. We should actually consider the definition of mediator again. Where is it? Mediator. Mediator means a person who is appointed to be a mediator by the parties or by a mediation service provider to undertake mediation, and includes a person registered as a mediator. I'll just highlight so that we will also understand. So this is one of the important definitions for us. Then we should understand what is mediation agreement. We had to understand this mediation agreement. So this will go into section 4. Just a second. Okay, can you all see?
Yes,
Okay,
it's
yeah.
visible.
Okay, let us go to section 4. So here is section 4. It talks about mediation agreement. A mediation agreement shall be in writing. So this is something which we have already taken in the PPT itself. What do you mean by mediation agreement? Now, so we are skipping this part. The next section is related to pre-litigation mediation, because in IBC again and again we are talking about pre-litigation mediation. So this is of very much importance to all of us. What do you mean by pre-litigation or the mediation? So this is something which we must understand. Subject to other provisions of this act, whether any mediation agreement exists or not. So these words are very, very important. Whether any mediation clause exists or not. I think I have moved a bit further. So let me just come back to that particular slide. Here we are, sorry. Subject to the other provisions of this act, whether any mediation agreement exists or not, the parties, before filing any suit or proceeding of civil or commercial nature in any court, may voluntarily and with mutual consent take steps to settle the disputes by pre-litigation mediation in accordance with the provisions of this act, provided that pre-litigation mediation in matters of commercial disputes of specified value shall be taken in accordance with the provisions of Section 12A of the Commercial Court Act 2015 and the rules made thereunder. So it is saying that if it is mentioning here that if it is of commercial nature, then the threshold limit is 3 lakh. So 3 lakh compulsorily they have to go with this mediation process. It's not mentioned here, but it is given the reference of Section 12A of some other act. So there it is mentioned 3 lakh. The provisions of subsection 1 shall be applicable to the tribunals notified by the central government, as the case may be, for the purpose of this section, so this third subsection is very, very important because it talks about who can become a mediator. So for the purpose of subsection 1 and 2, so these 1 and 2 cases are related to pre-litigation mediation, like in IBC, when we are filing section 9 application, before section 9 application, we will be actually facing this particular section. So for the purpose of subsection 1 and 2, that means pre-litigation mediation, unless otherwise agreed upon by the parties, a mediator registered with the council or empaneled by a court annexed mediation center or empaneled by an authority constituted under Legal Service Authorities Act, empaneled by a mediation service provider under this act, shall conduct pre-litigation mediation. So who is authorized to conduct pre-litigation mediation? Because in IBC again and again we are saying that it is all about pre-litigation mediation. Right, that discussion paper was purely talking about this pre-litigation mediation. So it was a choice given, but even if you want to go for it, who can become a mediator? So either that person should be registered with the council or empaneled by any court annexed for this mediation center or empaneled by any authority. So even if you have the experience, that is of no use. Even if you have done a certification course, that is of no use. You should be registered somewhere, you should be empaneled somewhere so as to become the mediator. That is the thing which we should understand. For conducting pre-litigation mediation under clause 2 and 3 of the subsection 3, a party may request any person designated for this purpose by the high courts, or okay, these parts are not that much relevant. We can move further for the next important section, disputes or matters not fit for mediation. So this they have mentioned it. It is given in first schedule, which we have already seen that suppose if anything is related to prosecution or any criminal proceeding, they will not fall into this category. Or any tax levy is there, then that also will not fall for mediation altogether. Then next section talks about power of court or tribunal to refer parties to mediation. So even court or tribunals have the power, they can refer the parties for mediation. So that is what we understood earlier, that voluntarily parties have the option, they if they want they may go themselves. Otherwise also NCLT and NCLAT, they have the option to refer the cases to mediation. So this is this is also mentioned in this particular section. Next is it is talking about mediator altogether. There is a separate chapter number 4 for mediators. So how this how appointment of mediators will be done. So appointment is particularly given in section 8. Unless otherwise agreed upon by the parties, a person of any nationality may be appointed as a mediator. So a person of any nationality can be appointed as a mediator, provided that such mediator of any foreign nationality shall possess such qualification and experience and accreditation as may be specified. So again, there will be a separate regulation for all this thing. Who will be a qualified person? What is the qualification? What is the experience and all? So that will be separately mentioned. The parties shall be free to agree upon the name of the mediator and the procedure for their appointment. If the parties do not reach any agreement on the matter referred to in subsection 2, then the party seeking initiation of the mediation shall make an application to the mediation service provider for the appointment of the mediator. So if both the parties are not agreeing to a particular person who can become a mediator, then they have to approach to mediation service provider to take their help. Then upon receiving an application by this mediation service provider, what they will do within 7 days of within a period of 7 days, they will appoint mediator as agreed by the parties, or in the case parties are unable to reach to an agreement, they will appoint a mediator for them. So this is something which we saw in the flow chart also. The person appointed under clause 1 of subsection 4, that means simply mediator, shall communicate his willingness or otherwise within a specified period of 7 days. So within 7 days, that mediator has to give his consent whether or not he wants to work as a mediator. So that 7 days criteria is mentioned here. Then preference of parties. Section 9, the mediation service provider shall, while appointing any person from the panel of the mediators maintained by it, consider his suitability and preference of the parties for resolving the dispute. So that is something which is purely an internal matter for the mediation service provider. Okay. The person appointed as a mediator shall, okay, this section 10 is talking about conflict and interest disclosure. So like in insolvency professional also, we have to disclose our interest, if any. And similarly, in the case of while we are appointed as an auditor, we have to disclose our interest if there is any. Likewise, here it is also mentioned the person appointed as a mediator shall, prior to the conduct of mediation, disclose in writing to the parties regarding any circumstance or potential circumstance, personal, professional, financial, or otherwise, that may constitute any conflict of interest or that is likely to give rise to justifiable doubts as to his independence or impartiality as a mediator. So, from this particular section, it can be inferred that a person who is appointed as a mediator cannot become the insolvency professional, because in that case his interest will be involved. Am I clear on this particular thing? This is what I can make out from this particular section. During the mediation, the mediator shall, without any delay, disclose to the parties. It is saying that without any delay, disclose to the parties in writing any conflict of interest referred above, that newly, if any reason, if any new conflict has arisen, maybe it was not at the time of appointment, but later on, if any conflict has arisen, then also he has to disclose. So this is all about the disclosure part. We can, I think, move further. Section 11, it is talking about termination of mandate of mediator. So whether the services of mediator can be terminated. Yes, a mediation service provider may terminate the mandate of the mediator upon. So these are the conditions of his termination. The receipt of application from a party. Any of the parties can apply for the termination. Then second, the receipt of information about the mediator being involved in a matter of conflict of interest from participants or any other person. So if if there is any conflict of interest and he has not disclosed, then again this may lead to termination of his services. His withdrawal from mediation for any reason. So there's an option for him also to directly withdraw. So mediator can himself withdraw from the case also. So this is an option given to him. I think this is a good option. If he wants to withdraw, he can, and then he may be appointed as an insolvency professional maybe later on. Upon termination of the mandate of mediator, so this is talking about the replacement of mediator. You can also replace him. So these are the few sections which were relevant for the mediator. Next chapter, chapter 5, it is talking about mediation proceedings, how the proceedings will take place. So territorial jurisdiction to undertake mediation. What shall be the jurisdiction? Section 13 is talking about that. Every mediation under this act shall be undertaken within the territorial jurisdiction of the court or tribunal of the competent jurisdiction to decide the subject matter of the dispute, provided that on the mutual consent of the parties, mediation may be conducted at a place outside the territorial jurisdiction also, and also by online mediation. So again, for online mediation, if parties are having mutual consent, then only they can go for this online thing. For the removal of doubt, it is clarified that where the parties agree to conduct the mediation at any place outside the territorial or jurisdiction or online for the purpose of enforcement, challenge, and registration of the mediated settled agreement, the same shall be deemed to have been undertaken within the territorial jurisdiction of the court, because obviously it was taken by the mutual consent, so there is no point doubting that. Next is commencement of mediation. So what is the date of commencement of mediation? So this we have already understood. If there is an existing agreement between the parties to settle the dispute through mediation, the day when they have given the notice or when the other party receives the notice for the mediation, then that will be considered as the date of commencement. In other cases where the parties have agreed to appoint a mediator of their choice for mediation and settlement of the disputes between them, on the date of mediator, on the date the mediator provides his consent to the appointment. So if his name was already there in the agreement, it was pre-decided in the agreement itself, there was a specific mediation agreement, then in that case, if as soon as notice is received by the other party, the mediator, that will be the date. Otherwise, then it will start from the date of consent from the mediator. That is the date. And where one of the parties applies to mediation service provider or the settlement of disputes through mediation, the date of appointment of the mediator. So if you are asking the mediation service provider to appoint the mediator, in that case, the commencement date will be starting with the date of appointment of the mediator. So this is something which we can note. Then conduct of mediation, how this process will be taken care, it will be given in separate regulations. It will be specified separately. We are not taking that. What is the role of mediator? Mediator shall attempt to facilitate voluntary resolution of the dispute of the parties and communicate the view of each party to the other to the extent agreed to by them. I mean, these are simple things. I mean, we can easily understand, but it is just that since it might happen that this forum is given to us to understand what is mediation all about, so let us just read this all together and make some picture in our mind that this is how this process will work. Role of mediator in other proceedings. So this is just talking about the role of mediator. So okay, functions we can easily understand on our own also. Time limit for completion. So this time limit we have understood that it is given in section 18 that it is to be completed within 120 days. So here it is mentioned 120 days. Then mediated settlement agreement. The definition is given here. A mediated settlement agreement includes an agreement in writing between some or all of the parties resulting from the mediation, settling some or all of the disputes between such parties and authenticated by the mediator. Okay, so here if you understand, it includes agreement in writing between some or all of the parties resulting from mediation, settling some or all of the disputes. So it might not happen that all the disputes are resolved. Even if you had suppose 3 disputes and only 2 disputes are resolved, then also this mediated settlement agreement can be prepared. So it is not that it will be considered as totally waste of time. At least 2 could be resolved. So that will be prepared. And for whatever item it is still open, you can further go for the next level. That is something which we should be aware of. Next, I'm taking this section. Registration of mediated settlement agreement. Then whatever agreement you have prepared, this has to be registered also for the purpose of record. Mediated settlement agreement arrived at between the parties other than those arrived in the court or tribunal referred mediation or award of lok adalat or final award of whatever may at the option of the parties be registered. Okay, it is again at the option of the parties be registered with an authority constituted under the act or any other body of the law. So it's a choice given to you. If you want, you can go for registration also, provided that the mediated settlement agreement under this section may be registered with such authority or the body situated within the territorial jurisdiction of the court or tribunal of competent jurisdiction. So this is okay. So registration is not compulsory. If you want, you can go for registration. Then this is non-settlement report. So we understand what is non-settlement report. If subject to the provisions of section 26, where no agreement is arrived at between the parties within the time period as provided in section 18, that is 120 plus 60 days, or where the mediator is of the view that no settlement is possible. So there are 3 cases. First, either no agreement is there. Second, time limit is already over. Third is then mediator is of the view that no settlement is possible. Then in that case, he shall, in the case of institutional mediation, submit a non-settlement report to the mediation service provider in writing. And in all other cases, he shall prepare a non-settlement report and provide a signed copy to all the parties. So this is how it will be done. So basically, in case of institutional mediation, there will be an intervention of mediation service provider. Then confidentiality, which we were talking about. Section 22 talks about the confidentiality clause. Subject to the other provisions of this act, the mediation service provider, uh, the parties and participants in the mediation shall keep confidential all the following matters relating to the mediation proceedings, namely acknowledgements, opinions, suggestion, promises, proposal, apologies, and admissions made during the mediation. Second, acceptance of or willingness to accept proposal made or exchanged in the mediation, documents prepared solely for the conduct of mediation or in relation thereto, or any other document or communication. So all these things are confidential. Then no audio or video recording of the mediation proceeding shall be made or maintained by the parties or the participants, including the mediator and mediation service provider, whether conducted in person or online, to ensure the confidentiality of the conduct of the mediation proceeding. So this is again very, very important. There cannot be any recording whatsoever, and even if you record, that will not be considered as an evidence anyhow. No party to the mediation shall, in proceeding before the court or tribunal, including arbitral tribunal, rely on or introduce as evidence any information or communication set forth in the above points, including any information in electronic form or verbal communication, and the court or tribunal, including arbitral tribunal, shall not recognize or shall not, take the cognizance of such information or evidence. So that is why this confidentiality clause is having so much importance. Then even if you take any evidence out of it and you want to show that, see, this is a disputed case or something, that will not be taken on records. Anything will not be taken as an evidence. The provision of this section shall not prevent the mediator from compiling or disclosing general information concerning matters that have been subject of mediation for research, reporting, or training purposes. Okay, this much part is allowed for them. Okay, so let us move further. I think you all are with me. Should I go ahead, or you wanted to read on your own? We have reached till 23. There are till 65. We can quickly walk through. So section 23, it talks about admissibility and privilege against the disclosure. I think we can skip this one. Then termination of mediation. When does mediation comes to an end? Because we know the commencement date, we should know when does it terminate also. So the mediation proceeding under this act shall be deemed to be terminate on the date of signing and authentication of the mediated settlement agreement, or on the date of written declaration of the mediator after consultation with the parties or otherwise, to the effect that further efforts at mediation are no longer justified, or on the date of communication by a party or parties in writing addressed to the mediator and the other parties, to the effect that the party wishes to opt out of the mediation, or on the expiry of the time limit under section 18. So this last part we all understand. If the time is over, mediation will terminate. C point simply says that any of the parties may at any time wish to opt out also. So if they are opting out, this mediation will terminate. Then as soon as they give their declaration in writing that they don't want to continue, then again this will come to an end. Or finally, it is saying that when you have finally reached to a conclusion, that is, you have formed this mediated settlement agreement, then this will terminate. Okay, the next question arises, who will bear the cost of mediation? The cost of mediation, other than the community mediation, shall be such as may be specified. Unless otherwise agreed by the parties, all cost of mediation, including the fees of the mediator and the charges of the mediation service provider, shall be borne equally by the parties. So this is again very important, who will bear the cost. So otherwise, because without having mutual consent, you cannot even go for mediation. Then next is proceedings of Lok Adalat and permanent Lok Adalat not to be affected. They can still go on. Next, chapter 6 is regarding enforcement of mediated settlement agreement. I think the name itself is very much clear that they shall, these agreements shall be enforced. and then they can also be put to challenge. Section 28 talks about the that they can be again challenged on these bases, on these parameters they can be challenged. So only on all or any of the following grounds the above agreement can be challenged. So if you think that it is based on fraud, corruption, impersonation, or where the mediation was conducted in disputes or matters are not fit for mediation, then only this can be challenged. Then limitation, which we were talking about, notwithstanding anything contained in Limitation Act 1963. So section 29 talks about the limitation period, or in any other law for the time being in force, in computing the period of limitation fixed for any proceeding relating to disputes in respect of which a mediation has been undertaken under this Act, the period from the date of commencement of mediation under Section 14 and up to submission of the report under Section 21 or termination. So from the date of commencement till it actually terminated, or finally, or the report was submitted. If the report was submitted earlier, then that date will be considered, or if perforce it had to terminate, then that date will be considered as the closing date. So that time period shall be excluded. It is clearly mentioned here, section 29. Then we have provisions regarding online mediation. This I think you can read on your own later on. Then this is Mediation Council of India. So who will establish and how this will be incorporated and all. Central government shall by notification establish for the purpose of this act a council to be known as Mediation Council of India to perform the duties and discharge the functions under the act, which is still under progress. Okay, and who shall be the part of it? What shall it consist of? I think this all can be read later. Vacancies, resignations of those, how those people can be removed, appointment of experts. I think this all can be studied later. Anything which we want to read? Monitoring, reporting. Then next chapter is mediation service providers and mediation institutes. So this is the definition which we have to read it. Section 40, subsection 1, mediation service provider includes a body or an organization that provides for the conduct of mediation under this act and the rules and regulations made thereunder and is recognized by the council, or an authority constituted under. So this definition I think we have studied earlier, which what will be considered as a mediation service provider. And what is their role? They will help appointment of the mediator. If the parties are not aware who is the mediator, they can approach this mediation service provider. So I think there will be a separate portal where all these things will be mentioned and people can, directly check that out. The mediation service provider shall be recognized by the council in the manner as may be specified. Then functions of the mediation service provider. This is something which we must understand. The mediation service provider shall perform the following functions. First is accredit the mediators and maintain panel of mediators. Second, they should provide the services of mediator for the conduct of mediation. And third, provide all facilities, secretarial assistance and infrastructure for the efficient conduct of mediation. So just like we have insolvency, we have a separate body for that also, no? In insolvency, we have individuals and then we have service providers also. So likewise, this kind of concept is here. Then mediation institutes. The council shall recognize mediation institutes to perform such duties and exercise such functions as may be specified. Then there is a whole chapter for community mediation. We can read this. Then next we have miscellaneous part where mediation fund is also there. There shall be a fund to be called as a mediation fund for the purpose of promotion, facilitation, and encouragement of mediation under this act. Okay, so this is something new. Then audit and account of maintenance of accounts of that fund. Obviously, that will come into picture. Then, okay, this is all miscellaneous. So I think we can proceed for the schedules which are there. So there are simultaneously amendments in all these acts with the, introduction of this Mediation Act. Okay, so this is the first schedule which we have, disputes or matters which are not fit for mediation. So this is mentioned in the first schedule, and the reference is given here of section 6. We have already taken this. The second schedule is again related to some particular section which we are actually not concerned as of now. Any other thing which we have to study? The third schedule. Okay, it's okay. I mean, the first schedule was very much important, which we have already understood. And there are how many schedules in total that we can check out? 11 schedules are there. This is the 10th, and I think there is one. The 10 schedules are there. There are in total 10 schedules. Okay, so that is the smallest act which you can say mediation act, and whosoever will appear for the exam now will have to read this mediation act as well. So what do you think? Is this an opportunity for us? I think we should wait for a while to settle. Let all the things settle also, because the environment is that it will be helpful for people. Mediation will obviously play a very important role. So meanwhile, what we can do is we can sharpen our skills to be a good mediator, and if allowed, then I mean, if your time permits, then you can go for the course under this particular mediation, a certification course for that, and then training will also be mandatory for that reason, if you really want to become a mediator. So any suggestions, any comments, anything to conclude with? Okay, Anjali ma'am, we can sum up if or anybody is willing to give any feedback.
We can conclude, ma'am.
Okay.
Thank you very much, ma'am, for giving your valuable time and the addressing session on the topic Bridging the Gap Creation and Future of IBC. Thank you very much for sharing your knowledge, experience, and learning with us. Ma'am, you are requested to please share the PPT.
Sure, I'll share it with you. Yeah, you can further share it with all the members.
Thank you, madam.
Okay, thank you, sir. Thank you so much.
Thank you so much, madam.
Thank you. My pleasure, sir.
Okay.
Thank you, ma'am.
Okay.